NRL and Optus saw the overturning of the decision of Justice Rares in the earlier case Optus and NRL. The full federal court held that, in creating recordings accessible by subscribers, Optus acted as the maker of the copy, either alone or with the subscriber, and that Optus could not rely on the Section 111 exception to copyright infringement, as the section did not extend to commercial use or where the person who made the recording did not do so for the purposes of using it. While it presented a significant step forward in the protection of content owners and exclusive licensees, it also left providers of new cloud-based technology uncertain as to what conduct, if any, was permitted under the Copyright Act. The case involved Optus's new TV Now service, which allowed subscribers to record television programs and store the recordings in 4 different formats for up to 30 days on Optus servers. Subscribers could later play back their recordings on compatible mobile devices or personal computers. In 2011, Telstra signed separate deals with both the AFL and the NRL for sole rights to stream matches live over the NextG network to smartphones and tablets. Telstra alleged that Optus's TV Now service essentially allowed users to subvert Telstra's exclusive rights by allowing users to stream the delayed game, and that Optus had infringed on Telstra's copyright under Section 87A of the Copyright Act. However, Section 111 permits a person to make a recording of a broadcast if it is for their personal and domestic use, for the purpose of watching it at a more convenient time. In response to Telstra's allegations, Optus commenced proceedings against the NRL and AFL, claiming their threats of copyright infringement were unjustified. Justices Finn, Emmett and Bennett heard the appeal and found 2 primary issues for consideration. Firstly, who made the recordings? Was it the subscriber, Optus, or both jointly? Secondly, if Optus was found to have made the recordings, did the Section 111 time-shifting exception to copyright infringement apply? The court found that Optus was the maker of the recordings in that the service it supplied to subscribers was to make, and to make available to that person, a recording of the football match he or she selected. Optus argued that they merely provided an automated service to allow for recording, and that it was only when the subscribers clicked on record that the copies were made. Because of this, they argued that they were not the makers. The NRL argued that Optus's making and storing of the copies on their servers was enough to class them as the makers of the material. TV Now captured, copied, stored and made available for reward the recordings, and the federal court considered Optus was manifestly involved directly in doing the act of copying. Using the definition of make in the Oxford English Dictionary as producing a material thing, the court concluded that Optus placing the copy on its hard drives and servers was enough to be considered making the copy. Optus tried to draw an analogy of a photocopier in a store, arguing that it was incorrect to consider the store owner the maker of anything customers copied on the photocopier. The court disregarded this analogy and suggested that the only appropriate analogy would be with a commercial photocopier, which copied copyright material provided to it for copying by it. They found that Optus's role in the making of the copy was so pervasive that it could not be disregarded when considering who did the copying. It was only by virtue of their system that copies could be made, and the continued existence of the service allowed subscribers to create the recordings. The question then became whether the subscriber too was a maker. The court's preferred view was that both Optus and the subscriber, acting together, were makers of the copies and were both liable for copyright infringement. The Section 111 exception applies to private and domestic use and provides that recordings made solely for private or domestic use do not infringe copyright. The court found that Section 111 could not be applied to commercial copying on behalf of individuals. More importantly, they found that the natural meaning of the section was that the person who makes the recording is the person whose purpose it is to use it. Because Optus did not use the recordings itself, its purpose was in providing its service for commercial profit and not for the purposes outlined in the section, and Optus could not rely on it. In presenting their findings, the Federal Court was careful to discuss the idea that the purpose of the Copyright Act was to allow for future technological development. However, they also stated that no principle of technological neutrality could overcome the clear and limited legislative purpose of Section 111. They maintained that it was not for the court to redraft the provision to secure an assumed legislative desire for such neutrality. They went on to state that, in their view, their findings were limited particularly to Optus as a service provider and TV Now as a service, and accepted that different relationships and technologies might yield different conclusions to the primary issues. After the appeal was allowed, Optus sought leave to appeal to the High Court, but were denied on the grounds that there were insufficient grounds for appeal. This left Optus with little choice. They shut down TV Now. The decision certainly prompted interest and discussion, with some warning that the decision could hinder development of cloud-based services. Optus were left to look to the Australian Law Reform Commission for satisfaction.